Hello friends, in the series on the income tax cases, we will discuss a very important issue on the service of notice in the present regime, where the notices are uploaded on the income tax portal and the proceedings against the assessee are completed, sometimes without sending the email to the assessee, and that email also at the proper email ID, and the proceedings are completed without serving the notices and without serving the assessment orders according to the section 282 subsection 1 read with rule 127 sub rule 1. Or in other words, the issue is that whether uploading of the notice on the income tax portal is the sufficient service of the notice. This issue has been taken by the Honorable Punjab and Haryana High Court in the case of Munjal BCU Center of Innovation and Entrepreneurship versus Commissioner of Income Tax Exemptions. This case has been reported in 463 ITR page number 560, and the date of the writ petition order is 4th March 2024. Friends, in the present case, a notice was issued to the assessee for completing the proceedings under section 12A subsection 1 clause AC clause III, and that notice was only uploaded on the income tax portal without sending any email to the assessee. After that, two more notices were uploaded on the portal, and that two notices were also not sent to the assessee through the email ID or otherwise, due to which the assessee was not able to give its reply to its submissions, and the order was passed against the assessee. The assessee filed a writ petition in the Punjab and Haryana High Court by taking the plea that on the co-joint reading of section 282 subsection 1 and rule 127 sub rule 1, it is obligatory on the part of the revenue to serve the notice or the orders to the assessee, in addition to uploading of the notice on the income tax portal by sending the notice to the assessee through the email or otherwise. Meaning thereby that if we read section 282 subsection 1 and rule 127 sub rule 1, then they do not mention that communication to be presumed upon placing the notice on the e-portal. Or in simple words, it can be said that by the co-joint reading of the section and the rule, it is very much clear that the assessee cannot be expected to keep the portal open all the time. Friends, since the assessee was not served with the notice through the email ID and the assessee was not aware of the notices, so the assessee could not reply and a adverse order was passed against the assessee. So it was the plea of the assessee that since I was not aware of the notices, so I could not give the reply, and apparently the principles of natural justice has been violated, and whatever the order has been passed should be cancelled, and I should be given a opportunity to give my submissions so that the proper adjudication can be done. The court said that whatever the orders have been passed without following the principles of natural justice, without serving the notice to the assessee, so that order is very much bad in law according to section 282 subsection 1 and rule 127 sub rule 1. Friends, the question arises that if the revenue uploads some notice on the e-portal and the assessee also log into the system for some other reason, for example for taking the printout of his return acknowledgement, then in that case whether it will be assumed that the assessee has logged into the system, so he must be aware of all the notices. So my considered view is that it should not be presumed the assessee is aware of the notice. But suppose if the assessee has logged in into the system and has clicked on the notice, because the revenue has the full information, because there is a complete login that the assessee has clicked that notice. So in that case, according to me, the assessee will not be able to take this plea that I was not aware of the notice. So be very careful and do not take these grounds just for taking the ground that the notice has not been served, because now in the computerization each and every detail is with the revenue. The revenue can come into the court and say that the assessee has clicked on the notice, so he must be aware of that. But there may be some other reasons also. The assessee can take the plea that my e-portal was assessed by my professional, so it may happen that my professional has clicked that notice, so I was not aware of that. So these are the matters of litigation. But as per this case, a straight rule comes that the notice and the order should be served to the assessee through email also, in addition to the uploading of the notice and orders on the income tax portal. Friends, this case is very important because as per my experience, a lot of orders under section 144, that is the best judgment assessment, has been done on the ground that the assessee has not replied. The simple reason is that the assessee was not aware of the notices. So this case can help him a lot. At the end of this video, once again I am repeating the name of the case. The name of the case is Munjal BCU Center of Innovation and Entrepreneurship versus Commissioner of Income Tax Exemptions, and this case has been reported in 463 ITR at page number 560, and the matter has been decided by Honorable Punjab and Haryana High Court. Thank you, friends.